Your Honor, calling People versus James Crumbley, case number 22279-989-FH.
The second parent of a convicted Michigan school shooter is preparing to head to trial. James Crumbley, the father of the shooter, faces 4 counts of involuntary manslaughter after his wife just got convicted of the same charges in a separate trial. We're breaking down the latest information from this week's pretrial hearing. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. You remember when we covered the trial of Jennifer Crumbley just a few weeks ago, the first parent in American history to be convicted for their child's actions as a mass shooter? Such a historic moment, such an important verdict. Well, I said at the time, that is only the first half. We have James Crumbley's trial up next. Now, the Crumbleys, of course, are the parents of the shooter who opened fire at Oxford High School in Michigan back in November of 2021. And the prosecutors contend that both Jennifer and James Crumbley, they ignored warning signs about their son's mental health, that they knew or should have known that his mental health was deteriorating, and they bought him a gun as a present just days before the shooting. And that gun is what the teenage shooter used to kill 4 students. And by the way, in terms of James Crumbley, as we heard in Jennifer's case, he was the one who actually purchased the gun for his son that day. So it adds kind of a different element there. Jennifer only found out about the purchase afterwards. Now, I mentioned the victims here. 17-year-old Madison Baldwin, 16-year-old Tate Meir, 14-year-old Hannah St. Juliana, and 17-year-old Justin Schilling. Now, there were 6 other students and a teacher who were wounded in this attack, but thankfully they survived their injuries. Now, Jennifer and James, they were each charged with 4 counts of involuntary manslaughter. Basically, it's like negligence, like they had a duty to take reasonable care and they failed to do that. Their cases were severed, meaning that they would have separate trials. And as we know, Jennifer went first. We covered her trial extensively here on Sidebar. And after emotional testimony from students, teachers, police, even Jennifer Crumbley herself taking the stand, the jury convicted her of all 4 counts. Her sentencing is scheduled for April. She's expected to serve her sentences concurrently, meaning at the same time for each count. So the maximum in prison that she faces is potentially 15 years. Now, James Crumbley, let's talk about him. So his trial is supposed to start in March, and we just had a pretrial hearing, and that's what we want to talk about right now. So Judge Cheryl Matthews, who is the same judge that oversaw Jennifer's trial, wanted to make sure that James Crumbley understood his rights since the cases were separated.
Can you tell me your full name?
James Robert Crumbley.
And how old are you?
47.
Can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
Can you hear and understand your attorney?
Yes.
Are you satisfied with her advice?
Yes.
Do you understand that you are charged with 4 counts of involuntary manslaughter?
Yes.
And do you understand that you have a right to conflict-free representation?
Yes.
Although there was formerly joint representation in this case, do you understand that attorney Shannon Smith represented your wife Jennifer Crumbley and that Ms. Mariel Lehman now only represents you?
Yes.
Do you understand that your own interests and your co-defendant's interests may be or later may be or become materially yours?
Yes.
All right. Do you understand that both your attorney and your co-defendant's attorney have indicated that there was previously a conflict of interest between you and your co-defendant, and that is why we have separate trials?
Yes.
Although there are now separate trials, do you understand that your co-defendant is a former client of your attorney?
Yes.
Do you understand that the duty of confidentiality continues after the client-lawyer relationship is terminated, which means that your attorney still must protect the confidentiality of privileged information provided by your co-defendant?
Yes.
Do you understand that given the duties owed to former clients, your attorney may be limited in their representation? For example, your attorney may not be able to use privileged information obtained from your co-defendant to further your own interests?
Yes.
Do you understand that these limitations can affect things such as decisions relating to the matters of trial strategy, for example, the presentation of evidence at trial, the examination of witnesses, the decision to call certain witnesses, also potential negotiations in terms of a sentence agreement, and also arguments made at sentencing?
Yes.
Do you consent to Attorney Shannon Smith continuing to solely represent your wife, Ms. Jennifer Crumbley, and Attorney Mariel Lehman continuing to solely represent you?
Yes.
Have you had the opportunity to consult with your retained counsel as it relates to the issue of your representation?
Yes.
Do you understand that by entering the waiver, you will not be able to raise these issues in an appeal should you be convicted?
Yes.
Do you have any questions about any of the issues raised on this form for either me or your attorney?
No.
All right.
Thank
Are
you.
you satisfied?
I am, thank you.
Okay.
By the way, not a surprise that their cases were severed or separated, because when we were listening to Jennifer Crumbley's defense at her trial, a lot of it felt like she was putting the blame and pointing the finger at James. So it would have been theoretically impossible for both of them to be tried at the same time. That wouldn't have worked. But now we're talking about his trial and this pretrial hearing. Now, in this hearing, the judge chose to only address one motion. It was a motion filed by the defense in regard to the prosecution and its witness list. They had an objection here. You see, the judge gave the prosecution a chance to explain first why their witness list changed. Now, one of the new additions or new witnesses that the prosecution wants to call is the original owner of that Sig Sauer 9mm handgun that was eventually used by the shooter. According to the prosecutor, that man bought the gun from the store, used it a few times, I think 3 times, and then sold the gun back to the same store.
So he was added in response to statements made by Jennifer Crumbley's attorney during her presentation of the case, as well as Jennifer Crumbley's testimony. Now, I don't know what counsel's argument is going to be regarding the firearm. I don't know if Mr. Crumbley is going to testify or what he might say. So we added that individual. He's potentially a rebuttal witness. Obviously, we have no obligation to identify rebuttal witnesses. However, should the argument be presented in a certain fashion similar to that of Jennifer Crumbley, I think the background of that firearm, how it was stored, how it was bought and sold would be relevant to the jury. So he was added after hearing the co-defendant's case in chief.
Okay, I'm not following. You're adding him for the purposes of rebuttal only?
Not necessarily.
Okay.
So again, it depends. I don't know how counsel is going to litigate her case, and obviously she's under no obligation to let us know that.
I was struggling with the relevance being my friend of the case.
So again, he bought the eventual murder weapon in May.
Okay.
He used it 3 times. He was provided with a cable lock. He never used the cable lock. He identified that as the same cable lock sold back to the firearm store,
Okay.
which in turn will be identified by those witnesses as the same cable lock sold to Mr. Crumbley.
Okay, I get it.
More specifically, why he's important, why this witness is important, is because he can testify about the condition of the cable lock on the murder weapon. That becomes a very big factor in terms of how James Crumbley secured or failed to secure that weapon. And the judge ultimately agreed to allow this witness to testify. But the prosecution also added 2 former students at Oxford High School to their witness list. They didn't testify in Jennifer Crumbley's case. They want them to testify in James Crumbley's case. Now, both have reached the age of 18, but they're still named in the court records with their initials. And both girls witnessed the shooting and can attest to who it was and what happened.
We are limited to the individuals we can call from that hallway because 2 were murdered in that hallway. So these are the 2 individuals that have the best perspective, who are now above the age of 18, who can actually testify as to what they saw, what they felt, what they heard as the shooter emerged from the bathroom and opened fire. It's not the same evidence as the video. The video has no sound. The video does not give that sort of depiction, that eye-level depiction, that eyewitness testimony. It is not cumulative. If we called every single student who's in that hallway, it could be cumulative, but we are being very selective in who we're choosing to call to testify, because we want to limit it to the individuals who can provide the appropriate context and appropriate perspective that is not identical to anyone else.
The defense basically said, look, if there's video, the witness testimony isn't really necessary. The court has already ruled that the video will be allowed in a trial without sound, but defense attorney Mariel Lehman says that testimony from the 2 students would be way too prejudicial against her client.
While I can't imagine what those 2 students went through on November 30th of 2021, their testimony is not relevant in the trial against James Crumbley. He's been charged with 4 counts of involuntary manslaughter. He's not charged with assaulting anyone with a firearm. He's not charged with shooting anyone and wounding anyone. He's charged with 4 counts of involuntary manslaughter for the actions of his son. The primary purpose of their testimony is to inflame the emotions of the jury. I mean, their testimony or whatever they can provide can also be provided in a video. The whole purpose of admitting the video and not having sound on the video was to lessen the prejudicial impact on the jury. If we litigated this previously, and this has been discussed with the court, the purpose of the video and admitting the video is to show the jury what actually occurred during that shooting. The shooting is caught on the video, Your Honor. So the court has previously decided that the video is being admitted. I still don't believe that it's relevant in this case, Your Honor. However, I know that that's the court's ruling. So allowing the testimony of 2 students who were not only in the hallway, but were also wounded by the shooter, Your Honor, I just don't find it relevant. And I think that it is, even if the court finds it relevant, it's highly unfairly prejudicial in this case.
And here was the prosecution's response.
Judges, I thought I heard a question directed at the prosecution from the court. So one thing, I definitely do not agree that the video is being played to inflame the jury. Perhaps counsel misspoke, which said prosecutor agrees that's the purpose. That's certainly not the purpose. And also, Judge, the shooting is relevant. This is a homicide case. The shooting is evidence of the gross negligence. So the 2 individuals we identified, they were not looking at the same thing. They were not oriented the same direction. They have different perspectives. And again, these are the only 2 surviving members of the hallway that we have confirmed with their families that they are willing and able to testify in this trial, Judge. We are, again, acutely aware of the toll it takes on individuals to testify. There's members of law enforcement who still can't talk about that day. And we're also aware to not put cumulative evidence in front of the jury because it doesn't have any purpose, Judge. So we're aware of all that. And just because we've added the witness list doesn't necessarily mean we're going to call all of them too. We still have 13 days to decide which witnesses will be presented at trial in which order.
In the end, the judge said she needs some more time to look at the case law before she decides about putting the student witnesses on the stand. So what about some of the other motions that the defense team has filed? Well, Mr. Crumbley and his attorney want to exclude his son's journal writings and text messages that he sent to a friend. He doesn't want the jury to hear that. In her motion, defense attorney Lehman wrote, quote, "In addition to the statements expected to be admitted, there are other statements in the journal which are contradictory and exculpate Mr. Crumbley. Allowing some but not all relevant statements will mislead the jury." Now, in one of those journal entries, the teen writes, quote, "I have zero help for my mental problems, and it's causing me to shoot up the effing school." Now, you can see why the prosecution wants that in, right? It goes to the heart of the issue that these parents ignored their son's pleas for help. Actually, I'll tell you, the jury foreperson in Jennifer Crumbley's trial said that journal played a big role in their deliberations. The problem, of course, is why did the shooter write this? What was the context behind it? Was he actually telling the truth? And the defense wants this out because they say the shooter, the defendant's son, is not going to testify. They can't question him about it. The shooter has said he will not testify, and that if he was forced to testify, he would just plead the fifth, his right against self-incrimination. The teenager entered a guilty plea and was sentenced to life in prison, but could still appeal, so he doesn't want to say anything that would jeopardize that. The defense argued, though, that since they can't question the shooter about the journal entries or texts, they shouldn't be allowed in. And since Lehman can't call the son to the stand, she wants to present some of his private medical information, specifically reports of what he told psychiatrists. You see, according to court documents, the shooter allegedly told a psychiatrist that he lied in a text to a friend when he said he asked his parents for help and they ignored him. Jennifer Crumbley's defense team made a similar argument, but the judge forbade the confidential records from being admitted. Now, the defense also wanted to have the trial moved to another county. They argue there was a lot of media attention on Jennifer's trial, and Lehman says it's going to be very hard to find a jury that's fair and impartial. In that motion, Lehman wrote, quote, "It appears that more people are interested in James and Jennifer's cases than the shooter's case, despite the fact that the shooter planned and carried out the school shooting, admittedly without anyone else's knowledge." The Oakland County Prosecutor's Office confirmed on Thursday that the judge denied the motion for change of venue, and we're going to be keeping an eye on the results of the other motions as we head for trial, scheduled to get underway March 5th. All right, everybody, that is all we have for you right now here on this episode of Sidebar. Thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.